Only trial courts determine the important facts called relevant evidence. In this module number 8, you're going to see how relevant evidence is put on the scales of justice and weighed in determining guilt or innocence. Focus not on the subject matter, but pay attention, please, to the different kinds of trial courts. We're going to be taking a look at small claims court with the magistrate, the district court that functions without a jury in criminal matters, and the highest trial court, the superior court. If one or both of the parties want to have an appeal of the trial decision, they may go to the Court of Appeals. And the highest court in the state is the state Supreme Court. So as you watch this video, it's kind of fun to see how a real case is handled, but pay attention to, please, the trial courts, because that's the focus of this Module 8. But right now, please enjoy the case of the drunk driver.
The search for truth. That's one of the primary objectives of our North Carolina judicial system. We'll recreate the steps of an actual criminal case, from the magistrate to district court and on to superior court. The issue? The defendant's guilt or innocence. The case of the State versus Francis Corso began as a question of facts. It then moved on to the Court of Appeals and the State Supreme Court. There, our case became a question of law and the legal process. Did justice prevail?
We were getting ready for bed when we heard this dull thump. No tire squeals, just a dull thump.
And when I looked in the passenger side window, she was unconscious and bleeding. So my husband went in and he called the police and the emergency medical team.
The ambulance took her on to the hospital just before you got here.
I got in the car and held up her head and tried to stop the bleeding.
I see.
The officer then went to the hospital to see if he could find out more about the crash and what caused it.
Dr. Hammer, Officer Butler, investigating the accident.
Officer, I'm Dr. Manley. Miss Corso is in serious condition, just stabilized. She suffered a severe head trauma, possible chest injuries, broken arm. She's still unconscious.
Well, she wasn't wearing her seatbelt. Her vehicle left the road at approximately 45 miles an hour. The cause of the accident's unknown at the moment. Could I take a look at her?
Thank you.
Thank you, Doctor. I'll come back when this comes.
Okay, people, let's get moving on this. You understand it? Get a CBC and a blood alcohol level. Also,
Officer Butler again visited the hospital. This was his second interview with Miss Corso since the crash.
Good evening, Miss Corso. How are you doing?
Good evening, officer.
You feeling better the other day when we talked?
During questioning, Miss Corso said she had only 2 drinks with dinner.
I had a cocktail. I had two cocktails.
Officer Butler then interviewed the couple Francis Corso had dinner with that night. He heard a much different story about how much Miss Corso had to drink. Based on the officers' reports of witnesses and friends, the district attorney asked for Francis Corso's medical records from the hospital, specifically the blood alcohol test result. This test was part of the standard set of tests done by the attending doctor to deliver treatment to Miss Corso in the emergency room. The blood was drawn for medical reasons and not at the request of law enforcement officer Butler. This point became very important later on. Miss Corso's blood alcohol level was .178, well above the state's level for driving while impaired. Based on this information, a warrant was issued for Francis Corso's arrest for driving while impaired. The warrant for her arrest began her process in the North Carolina judicial system. After a warrant was issued, law enforcement officers took physical custody of Ms. Corso. She was then presented to a magistrate.
The purpose of this proceeding is to set the conditions for your release and set a court date for trial. Now, you've been charged with driving while impaired. I see you've got an attorney here. Would you like to be heard, counsel, on the conditions of release?
Yes, Your Honor. I'll only say that Ms. Corso has been a member of this community her entire life. She's fully employed from a good family, no past criminal offenses. I assure you she'll be in court on the appointed date.
Ms. Corso, under the circumstances, I'm going to set the conditions of release for you at $300 unsecured.
Numerous civil cases and minor criminal cases are heard by the magistrate. It is the responsibility of the magistrate to determine if a case should move to the next level of the court process.
A magistrate sees things very differently from other judicial officials in the system as he sees them when they've just happened. The blood's still wet. The DWI offender's still drunk. The police officer's still fired up with adrenaline from the chase, quote unquote. The magistrate has a perspective that is different from a district court judge or superior court judge, as the magistrate is the front-line judicial official. They're there when it happens, and they're charged with viewing the situation as it has just unfolded.
Francis Corso began the trial of her criminal case in district court. The district court sits in every county, including the county seat, and handles civil, criminal, juvenile, and cases of the magistrate. The trial of a criminal case in district court is always before one judge and with no jury.
Is the state prepared to go forward?
Your Honor, the state is prepared to go forward.
And is the defendant prepared to proceed?
Yes, Your Honor.
What matter are you calling at this time, Mr. D.A.?
Your Honor, I now call before the court the state of North Carolina versus Francis Corso. Mrs. Corso is before the court on the charge of driving while impaired, which is a violation of North Carolina General Statute 20-138.1.
What saith the defendant?
The plea is not guilty, Your Honor.
Very well. The state may proceed by calling its first witness.
Your Honor, I now call Officer Butler.
Officer Butler, please come forward and be sworn.
Mrs. Melvin and I concluded my investigation of the crash site and then proceeded to the hospital.
When you arrived at the hospital, did you speak to the defendant, Francis Corso?
No, sir, I did not. When I arrived, the defendant was unconscious. She was being treated by the attending physician and was listed in serious condition. Because of statements made at the crash site by witnesses who said they had smelled the odor of alcohol on Mrs. Corso, I tried to determine whether Mrs. Corso had been driving while impaired. In the hospital, I did detect a slight odor of alcohol, but at that time was unable to form an opinion that the defendant was impaired in any way.
Also, did you order a blood sample to be analyzed for blood alcohol content?
No, sir, I did not.
I got into the car, and I held her head up trying to stop the bleeding.
And how long were you there?
About 20 minutes until the emergency medical team arrived.
While you were in the car holding the defendant's head, did you notice the smell of alcohol on the defendant's breath?
Oh, yes. I could definitely smell alcohol on her breath.
Did you order a set of laboratory tests on Mrs. Corso?
Yes, I did.
Are these tests standard in treating a trauma victim of Mrs. Corso's nature?
They are. They are necessary for treatment purposes. We have to know what's in the patient's blood before we can treat them.
And the test for blood ethanol level was one of those standard tests done?
It was.
And what was the result of that test?
The blood alcohol level was 0.178 grams per milliliter of blood.
Mr. Sasser, the state has rested its case. You may proceed with the call of your first witness.
Your Honor, I renew my motion to suppress admission of the blood test into evidence. Now, I move to keep this evidence out on the grounds that the test was not properly conducted.
Mr. Sasser, your motion is denied, and the blood test results will remain in evidence.
Based on the evidence presented in district court, Francis Corso was found guilty of driving while impaired.
I serve as the sole decision maker in the matters appearing before the court. In criminal cases, for example, that would mean that I'm serving both as the judge and the jury, and must hold the state to its burden of proof, which would be that they prove each and every one of the elements of the offense alleged.
Following the guilty verdict in district court, Ms. Corso appealed her case to Superior Court. In criminal cases that are appealed from district court, the defendant gets a whole new trial called a trial de novo. This right to trial by jury is guaranteed under the Sixth Amendment in the Bill of Rights.
The trial of a case, and particularly the trial of a case in Superior Court, is a search for the truth. And the judge serves as a guidepost and as a leader for the jury, directing them into how they are to search for the truth and arrive at the truth of the case so that their verdict will be truthful and will represent what actually happened.
Mr. Sasser, from the evidence presented in the absence of the jury, from the arguments that you and the district attorney made, and having conducted my own research into the law of North Carolina, your motion to suppress is going to be denied, and the evidence of the blood test results will be presented before the jury.
Your Honor, for the record, I would like to object and take exception to your ruling.
Your exception is noted for the record, but your objection is overruled.
In district court, the verdict was decided solely by the judge. But in Superior Court, trial was by a jury of 12 people. The Superior Court trial was held as if no other trial had taken place before. With the evidence of the blood test results admitted, Francis Corso's trial started all over again. The jury of 12 was selected, and each side began presenting their views of the case.
Ladies and gentlemen of the jury, the state will prove, and the evidence will show, Francis Corso was in fact driving while impaired. And as a result, she was involved in a single vehicle accident on State Road 1044.
Your Honor, ladies and gentlemen of the jury, the defense will show that Ms. Corso did not consume enough alcohol to have the excessively high numbers that the blood alcohol test shows. The defense will also show that the blood alcohol test itself was performed improperly.
During my investigation, the defendant told me on February 17th that she had consumed 1 beer after dinner. 2 days later, on February 19th, she told me she had had 2 glasses of scotch and wine with dinner. I then interviewed Mr. and Mrs. Schobel, whose dinner party Ms. Corso was visiting that evening.
Ms. Schobel, can you tell me exactly what Ms. Corso had to drink on the evening of the accident?
Well, what did she tell you?
Ms. Schobel, I'm interested in what you actually saw Ms. Corso had to drink that evening.
Well, on the way home, we stopped and had 2 cocktails. Then when we got here, she had maybe 2 drinks before dinner. I can't really remember. Then we had a bottle of wine with dinner, but that was for 3 of us. And she had a cognac after dinner. But she wasn't drunk when she left.
Due to these conflicting statements, I felt I had probable cause to ask the district attorney's office to order the hospital to release the results of the blood alcohol level test.
The jury heard testimony of several witnesses telling of smelling alcohol in the defendant's breath and of the blood test results at .178. Based on the evidence presented and the admissibility of the blood test results, a Superior Court jury found Francis Corso guilty of driving while impaired.
Upon the jury's verdict of guilty, it's the judgment of the court that Ms. Corso be sentenced to serve a term of 30 days in the county jail. The sentence is suspended. She's placed on probation for 3 years on the condition that she pay a fine and court costs, and upon the further condition that she not drive an automobile in North Carolina for a period of 12 months.
Thank you, Your Honor.
That's all right. We're going to appeal.
Ms. Corso then appealed this decision to the next level in the North Carolina judicial system, the Court of Appeals. In our state, anyone convicted of a crime has the right to have their trial reviewed by the Court of Appeals. But in North Carolina, only 1 to 2% of all the cases are actually appealed. In the case of our defendant, Frances Corso, the question put to the Court of Appeals was not of her guilt or innocence. This court decides only questions of law. In other words, was it a fair and correct process that found Frances Corso guilty? In the Court of Appeals, 3 judges study the records and transcripts of the trial and hear 30-minute arguments on the procedures followed during the trial. No new evidence or testimony is introduced. The court record serves as evidence, since what is at question are points of law and how the trial was conducted.
Your Honors, the issue of appeal is clear. The Superior Court made a mistake in admitting the defendant's medical records, including the results of a blood alcohol test. Now, state law says that a law enforcement officer must request a DWI blood test, and that the person administering the test must be certified by the state to do DWI blood tests. That didn't happen in this case. And we ask that you overturn the Superior Court verdict on the grounds that the test did not follow the procedures of driving while impaired laws.
The state contends that the trial court did not commit prejudicial error by allowing into evidence Ms. Corso's blood analysis results. Although Ms. Corso was unconscious and in the hospital at the time her blood was drawn, the statute clearly allows into evidence the results of, and I quote, other chemical tests. This was such a case of another chemical test. The trial court did not err.
The job of the Court of Appeals is to review what went on at the trial level to determine if the proper procedure was followed, if the substantive law was followed, if the trial itself was fair, to determine if there were errors committed, and if there were errors, were the errors sufficient in law to amount to an unfairness or to require a new trial.
After careful consideration of the points raised by both attorneys, the judges presented their opinion. The decision? The Court of Appeals held that the trial judge made a mistake and should not have admitted the blood test. The Superior Court decision was reversed, and a new trial was granted for the defendant, and it would be a trial without the blood test results admitted as evidence. But remember the law. In our state, the losing side may have the right to appeal and be heard. In certain instances, the state has the same right to appeal, and did in this case. The state versus Frances Corso went all the way to the state Supreme Court. Only 150 to 200 cases are heard by the state Supreme Court each year.
You know, the Supreme Court has 7 members. The idea behind having 7 people decide these cases is that the collective judgment of the 7, the collective wisdom, if you will, of the 7, is better than the judgment of any one of us.
Oh yes, oh yes, oh yes. The Supreme Court of North Carolina is now sitting for the dispatch of business.
The 7 justices on the state Supreme Court heard the case of the state versus Frances Corso. Like the Court of Appeals, the Supreme Court was questioning how the law worked in this case, not guilt or innocence. The question here was, did the Court of Appeals make a mistake in reversing the trial court decision to allow the blood test? In essence, was the defendant's trial fair?
The state respectfully suggests that the North Carolina Court of Appeals erred when it concluded that the blood analysis tests of Ms. Corso were inadmissible in evidence. The state feels very strongly that the Court of Appeals overlooked.
Meaning that any time a person goes to the hospital, he's there for, she is there for treatment, that anything the doctor gets is then available to the law enforcement to be used against it. Isn't there something fundamentally wrong with that?
I would agree, Your Honor, that certainly it ought not to be wide open. There are circumstances, however, such as this case.
Show that statements by lay witnesses at the scene of the accident unduly influenced the jury in Superior Court. Also, we'll argue that Ms. Corso's rights to due process were violated under the constitutions of the United States and of the state of North Carolina.
In the case of the state versus Corso, the Supreme Court decision was this. It is the holding of this court that the hospital's evidence of the defendant's blood alcohol concentration was admissible in this case. The Supreme Court overturned the decision of the Court of Appeals. The guilty verdict of the Superior Court was upheld. Francis Corso's conviction for driving while impaired would stand.
Alrighty, let's recap the trial courts. It is important that we remember that trial courts are the ones that determine the evidence. First of all, we have small claims court, and small claims court is the most important court for business people. This court has the jurisdiction. That means the power and authority to take care of things of $5,000 or less. All right? Also in small claims court, it's not important to have attorneys. Well, and by the way, you can use the word attorney or lawyer. They mean exactly the same thing. Now, in the videotape, the lady came before the criminal side of small claims court, before the magistrate, whose job is to determine how much bail should be set. And the magistrate listened carefully to what the defense attorney said, and the defense attorney wanted her out and be released so she could help with preparation for her trial. Also, both the defense attorney and the magistrate know that the cost of putting somebody in jail, waiting trial, is $68 per day. That's a lot of money being spent by the taxpayer. So whenever possible, the folks want to be released to help prepare for trial. What the defense attorney said was, Your Honor, she's never been in trouble before, she's got a good family background, she's got a job locally, and I know that she'll be present for all of the court trials. Now remember, you're taking a look at small claims court, and that's not a criminal court or a civil court. It is a court that has both civil and criminal jurisdictions. Now, the next court is district court. District court handles traffic tickets and misdemeanors that are minor crimes. District court also handles civil actions, and this means one person suing another for up to $10,000. Also in district court we have folks who don't get along anymore, and so we have folks who are involved in divorce or child custody. The highest trial court in this state is the Superior Court. And Superior Court handles the major crimes, felonies, murder, rape, arson. Also Superior Court handles civil disputes of more than $10,000. And remember, the most important thing about trial courts is they determine the relevant facts. Not the Court of Appeals, not the Supreme Court, but it's the trial courts that make the difference. Coming up in the next module, you're going to learn about the nation's highest appellate court, and that'll be in module number 9.